Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And Justice Serve TV back on the air. Hi, Linda Kenny Bodden.
I am taking my headroom down because it was a day. I can't even say hello to you. I don't have time to say hello.
Yeah, don't bother with niceties.
Don't bother with the niceties.
Just
By the
get
way,
right into it.
Check out our new open. Did you see our new open?
There's just a couple of tweaks, just little tweaks with your, your Alan Jackson admiration hit.
Yeah,
and then,
Alan Jackson, who loves me, even though we fought like the Dickens for 6 months, and it was sort of a draw. I mean, well,
Do you
when you have
think-
a hung jury, no, it was a win actually for me because a hung jury for defense attorneys.
That's right. Do you think when this is all over that he's going to be saying, "Hank Brennan, I love you"? Think that's going to happen?
No. You know,
All
but
right.
you have to have a mutual respect. I mean,
Of course.
we fought we fought constantly. But for the most part, and maybe there were one or 2 points that we would disagree. It wasn't dirty, right? It was upfront. And it was on the merits and of our legal acumen, which I mean, like warriors, and that's why, quite frankly, I love our warrior song that we use for the person of the week. I love that song.
I do
but
too.
you know, gee, what's happening?
So anyway, nothing happened today.
I'm stretching, doing a little exercises, a little yoga, trying to get. Oh, look at this! I am so undressed that my earpiece wire.
Oh my gosh, that is
hanging
just
out
outrageous.
the back. Please excuse me all.
Okay. So we knew Judge Bev had promised before the end of the day she would issue her ruling on the motion to dismiss. Also on the buffer zone, although she did it on the buffer zone, it kind of got lost in the shuffle. I don't know. Did that actually get released?
I don't know, but when I assume it did because people were commenting about it. How could you have a buffer zone that big when actually the farmers markets don't start until June 7th, which is what my point on Saturdays. Okay, and last time we looked, there wasn't a court on Saturday.
So what is the buffer zone? What is it?
I don't know.
We don't know if that was released.
They have given a
500. Anybody hears about that? Let us know. It was 200 last time. They requested 500 this time. Judge was going to give it a look-see, and we'll see how it goes. We gave a look-see to a 36-page decision on the motion to dismiss.
You know,
I would say it's a full-throated decision. Would you say
it's a full-throated decision, and it was a day of surprises. Do we want to start with the first surprise?
Oh, I don't know. Do you want to bury the lead, or what do you want to do here?
I want to bury the lead so that we can
bring it.
Wait, so you know why? So we can bring the lead up and have it resurrect.
I have no idea what you're talking about, but I will find it here. I've kind of buried it in my own little mess.
You all didn't know, earlier today there was a decision in favor of the defense, and it was so astounding that we actually, and I don't know whether you've put them into assets, we actually have a screenshot of Bob Alessi, Robert Alessi, Mr. Alessi, Attorney Alessi's.
And I don't have, but we have this.
Okay.
Supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to give you this information, Mr. Brennan.
Okay, then. It never gets old, does it? When she's.
I actually heard what you said there. I'm not going to give you this information, Mr. Brennan.
Yeah.
That's what she said. I've been all day trying to figure out what she said.
After she said, I understand the waiver argument. Yeah.
Right. And we all thought that meant that Judge Beverly Canoni was going to rule against every single attorney in the United States of America and allow the breach of the attorney-client privilege and also allow Mr. Yannetti and all the attorneys' malpractice, especially Mr. Yannetti's carrier, to be notified for a possible breach of attorney-client privilege suit. But no, she didn't do that. She surprised us. And quite frankly, when we do pull up Bob Alessi's picture in our frame, I tweeted it earlier or X'd it or whatever I did. And it was like, it was frozen. It was frozen.
He was frozen.
It was the ruling held around the world for attorneys. All right.
Yep. So that related to the attorney-client privilege issues, which we
such a big deal.
Of course, it's a big deal. So that was this morning. Not the first thing they got to, but we still haven't heard any ruling on the third-party culprit stuff, which was argued this morning. But as I said, she promised by end of day that motion to dismiss will be ruled upon, and the buffer zone. So the motion to dismiss has been it's risen from the grave, I guess.
It is risen from our lead is now our lead. We've given chance for people to get into the chat. Let's talk about this. Yes, the motion to dismiss, the fully throated decision on the fully throated motion to dismiss has been fully throated released.
There it is. There's the top. Okay. So 36 pages of fun. I'm just going to scroll slowly. A lot of it's just the setup stuff. Nobody gets too excited about that. Of course, you can just jump right to the bottom. There's the motion is denied. Okay. Then the fun begins, right?
Right.
Let's see. Okay. So a little bit of law up top about what this means and how, and we know, let's not fool ourselves here. The odds of this being granted were minuscule. Even in a case where we think so many egregious, inappropriate actions or inactions took place, it is the most, final of any penalty sanction you might give.
And she points it out.
Case. Of course, she has to. The law supports her decision. So I think the interesting thing is how she does it factually. What things she focuses on to justify not granting the motion. And as you see them, laying out in this 30-some pages, you go, yeah, I remember that. I remember that. I mean, there's so many. I'm going to steal from Alan Jackson's closing argument from trial number one. I'm actually
looking for my whole 39 pages that I printed out here.
No, see?
Yeah.
I left mine to the electronic world. I'm steal from Alan Jackson's closing argument. Look the other way. Just look the other way. You see all these things come along, just look the other way. And that's what the judge has done here with this motion. So she has itemized everything that she's looking the other way on and coming to the conclusion, it wasn't that bad. Wasn't so bad, right?
Well, yeah. Well, it was not the type of violation, she said, that, and we can go through this. It's all in the footnotes, right? That the defense, being as good as they are, pat you on the back. That's that whole theory. You're so good, defense, you couldn't deal with it. It's not so bad that you can't handle it in the second trial, because even if it were egregious in the first trial, here you go. You got a second chance, aren't you guys?
So
lucky.
You got the ultimate remedy. You got another trial. So it's not like a motion for new trial or something else where there is no opportunity to correct it through a second trial. She's basically saying, as bad as it might have been, you got another shot at it anyway. So,
and there's a third thing. And, the rules that existed for discovery and Brady that Massachusetts had on the first trial, they didn't cover everything you asked for, everything that was done, everything that was hidden, everything that was turned over. They didn't cover that then. So I really can't look at this motion under those rules. Now, maybe under the new Rule 14 that of a committee that I headed, it may be different. But, we can't go there because that's not the situation. And, now you have everything, we think.
Yeah,
so
and
there you go.
And you're talking about Bev heading that committee. Right. And it's not retroactive. We get that. And she mentions a few times that the Rule 14 in place at the time of these various things provided for A and not B. And so if I want to find something positive, I can say, well, at least there's an acknowledgement that things should be better going forward for somebody else. Doesn't help Karen Reed, but it
doesn't help her at all. And it also is a little bit of a dig in the sense of, she says the Rule 14 previously didn't cover video. And you didn't ask for video.
I mean, let's get to that. It's just so
okay. We'll get to that. But I'll tell you, these are the high points that when we get to it, I'm going to be looking at. So if you want to scan your decision, if you have it electronically, those of us who are following us, you can look for these.
You're going to see we've highlighted most of, at least for the first part of this motion. I kind of fell off after the jury tampering, which I thought was a long shot anyway. So one of the ultimate conclusions is, as discussed below, and we'll get to that, defendant has not demonstrated that she suffered any prejudice as a result of discovery violations that cannot be cured by a new trial, and has not substantiated her claims regarding interference with the jury, which, as discussed in detail below, are baseless. So she pees all over that one very quickly. And again, I didn't think it was all that strong, but it was worth addressing. Okay, so let's talk surveillance footage, shall we?
Well, can we talk a footnote first?
Which
before we
one?
talk- Well,
Give
it
me a number.
actually, well, it kind of comes in surveillance footage. It is footnote number. Hold on a second. You know what? I have to change my glasses, Michael, while
Okay.
you are scrolling and talking. Of course, I would like to find my glasses. Hold on one second. Let me see. I want to make sure I
I'll
have
just
this
tell you
right.
the first footnote references Rule 14 and the changes and what they do mean or don't mean.
Right.
The footage is picked up in the second, third footnotes.
Yeah, and it's actually where I put a footnote under 4. And the only reason I did that, okay, because when she's talking about the Sallyport driveway footage. I'm going to use the driveway footage. I'm going to use that as Sallyport generic, right? Everything with regard to that is generic, okay? Sallyport. And I did a note to myself so I could talk to you about it. These footnotes, man, a footnote, if really is important, I wrote impolite on my own self, but if it's important, should be in the main opinion. But these are super important footnotes for the defense. But what happens? They're minimized by literally minimizing them into a footnote. Okay? So with that, we can discuss.
Some would suggest you're hiding some things in the footnote as well. But
one could suggest that.
One could say that. So the lead investigator in this matter, this is setting up the footnotes, Massachusetts State former trooper, Michael Proctor, took possession of requested CPD video of the Sallyport in February 2022, but did not turn it over to prosecution. Instead, why? For reasons unclear on the record, he kept the material in his case file. Just look the other way. Don't worry about it. We're not sure why he did it. Not a big deal. Just move on.
Right.
Okay. So then we move on to the 29th, the day in question. CPD gave state police the video from the main driveway side exterior Sallyport camera. Proctor took possession of the video, but again, for reasons unexplained, did not turn it over to the prosecutors. Instead, he placed it in his case file. So just look the other way. And by the way, the recording is
covering
dark.
the prosecutors there too, you say.
That's right. The recording is dark, blurry, and grainy, and the condition of the passenger side taillight, a significant issue in the dispute, cannot be discerned. So again, don't worry about it. You didn't get it. It's not worth much anyway, right?
That's what she's saying. She's saying it's not going to give you much in your evidentiary value anyhow. So therefore,
yeah. What's the harm? Okay, so let's play What's Redacted. This is the end of the sentence here. Yes. This is from page 7. Yeah, Proctor testifying to the federal grand jury. What do you think is in here? What did he say to the grand jury regarding Officer O'Keefe's death?
His death. Blank. He I wonder if he said there wasn't any Sallyport video. I wonder if he said,
or he said he turned over everything to the prosecution, which we know is not true,
or something or other. I mean, there's something. I mean, what could it be? Let's guess at what this could be, because why would you need to hide what he said before the federal grand jury unless it gives you an idea as to what the grand jury was investigating, right? Because that's supposed to be secret.
Correct.
Now, if this is redacted and it's supposed to be secret, somebody knows, like the prosecutor, right?
Yeah, you would think. Maybe
the defense.
Here's what I'm deducing from this. Okay, and I'm looking at what comes before, what comes after to get there. It's about the surveillance video, because if you look at what immediately follows, 3 months later, on April 4, 2024, remember that's about the time the first trial began. Right. It was the 16th. Adam Lawley received Proctor's federal grand jury testimony. After reading that testimony, Lawley asked the trooper if he was in possession of the video footage referenced therein. So there's something in the grand jury testimony referencing the video, right?
Right, has to be.
In response, Proctor gave Lawley the Sallyport front wall camera footage provided to Proctor in February 2022, but not the main driveway side exterior Sallyport footage provided in June of 2023. Again, that's a year and a half after the incident. Lawley immediately turned over the Sallyport front wall camera footage to the defense, along with the footage from the main driveway showing the SUV on the flatbed. None of this footage contained a view of the back of the defendant's SUV. Funny about that.
Isn't that
So
amazing? So then what
now
do you deduce is in the redacted
I
text in
I
there?
can't get any more specific than I believe it was his testimony about the chain of custody of the video, when he got it, what he did with it, who he got it from, where it was kept, why he delayed. That's what I think.
So do you think that they're covering an investigation into somebody else besides Proctor, and the grand jury was investigating in this redacted portion, which of course I can't point to, that they were investigating someone else? Is that what this is?
Didn't the Proctor family say they're going to appeal the decision from the board?
Yes, they did.
And that could mean that they felt this should be protected and still all appellate rights have been exhausted.
But I'm not sure then if indeed it's the chain of custody of who he gave it to, or somebody who said to him, you know, this is the actual footage or something. Would that give us an indication of who the federal grand jury was investigating, which can't be revealed because there was no indictment on their investigation?
True. And if there were others that haven't officially been, exposed, that they're still trying to protect, they're still investigating, maybe. I mean, we're talking about 2.5 sentences, right?
I know, but it's a 2.5 sentence into what the feds were doing, which I think is going to become important for the whole ARCA issue, right?
Yeah. Well, it's grand jury testimony, so I think that's why it's super sensitive, and we won't know. We may never know what it directly relates to.
Right.
Okay, so
but why can we go back to the footnote? It is unclear to the court why Proctor. Oh, I'm sorry. I apologize.
Yeah, I wanted to finish the sentence.
Okay, got it.
And then the footnote is unclear to the court where the CPD main driveway footage came from. Who knows? Just came out of somebody's rear end.
And why Proctor requested it at that time? You did get to that, and why he requested it at that time. So, wouldn't have the federal grand jury asked him why he requested at that time if it's unclear, or does she not have access to that?
I don't know. The CPD main driveway camera appears to show a different view than the main driveway side camera. The recording from that camera remained in Trooper Proctor's file. So, again, the mystery. So you can just start adding these things up, but again, just look the other way. It's not a big deal. The Commonwealth explained that the footage was intermittent. Remember, there was the issue with the camera working, not working.
I think it was 45 footage. Minutes. Yeah.
Only 42 minutes.
42 minutes.
42 minutes missing. The Commonwealth explained that the footage was intermittent because the camera was motion activated. Okay. So I seem to recall having seen some of that video when there was nobody in the shot and therefore no motion. Now, it could be, because I know some of these cameras work this way, they have a run-on period of time. So it may stay on for 30 seconds or a minute after any motion is detected. Yeah, who knows? These cameras are so screwed up. Who knows what they were able to do or not do?
Right. Only 42 minutes missing.
Only 42 minutes. I mean, that makes Nixon's 18 minutes look like, jump change.
Rosemary Woods, that was his assistant,
Rosemary.
Right? At that time, who supposedly had possession and accidentally deleted some very important thing in the Watergate prosecution. You can look it up as a historical prosecution.
Yes, back in the 70s.
In the days back in the days when if you deleted tape of some sort, audio tape, then it was considered really suspicious. Okay.
Now it's just look the other way. And back then, you had to. If you didn't destroy the tape, you would have to have, white noise or something that obliterated that part of the audio if the tape was still intact. It was quite the process before digital. So,
or you just threw the tape away. I mean,
you could do that. But this one was like in the middle of a tape, right? It was in the middle of a conversation.
Right, it was in the middle of the conversation. That was in the middle of the conversation, right? The tape existed, but in the middle of the conversation, somehow it was like CIA erasure.
So anyway, only 42 minutes. Not like it was the whole lunch hour, Linda. I mean, come on, don't go crazy.
Well, certainly not for this jury trial. This 42 minutes would be a shortened lunch hour.
Okay, so where are we now? We're at the top of 8. talking about the trial began. Oh, on the 16th. Okay. On April 17th, this is day 2, Lally received footage of the Sallyport interior back wall camera from CPD, which had been looking for continuous camera footage of the Sallyport. This is the second day of trial. Here's some more footage for you. On April 23rd, Lally provided the Sallyport interior back wall footage to the defense. But shockingly, I added that. The images contained in this footage were inverted. But did he say that at the time he handed the video over? No, he did not. The direct testimony, as I move down here, did not alert the jury that the video was inverted. On cross, however, and this is, I love this. This is where the judge turns good lawyering by the defense into a weapon against the defense.
Right. Such a good lawyer here. He's such a good lawyer.
The direct defense did not alert the jury, but on cross, defense counsel questioned Buchanan extensively about the inverted image. So in other words, you're exposing this issue live and in front of the jury. We're going to now hold against you because you were so good. You can't be prejudiced by it because you caught it. You caught it and you told the jury about it.
Right. Instead of there being a you cut down the apple tree, right? And you have a demerit, or you have a penalty, or your allowance is taken away for a week. If people still have allowances, right? Yeah. Well, okay. Okay. We just grew another apple tree. It's okay.
Yeah. You can go back to George Washington, who cut down the cherry tree.
Oh, it was a cherry tree. He cut
It was
down.
a
Oh my
cherry
gosh.
tree.
Yeah.
So,
I mean, my gosh.
I wasn't there, but that's what I recall.
And I do want to jump ahead on this. Only reason why is because this whole idea of you're such a good lawyer, right? You covered it and you protected the client's rights and all that. She then takes a dig later on at the defense regarding the fact that I assume even if you didn't have it, it was your fault you didn't have it because you never properly asked for it.
And I love that part, which we get to here. And we talked about this early on before the court put this decision into words. And we're like, how do you hide behind what is obvious? They're requesting for the crime scene. We will get to the details of that discussion. The crime scene. Obviously, at the time it happened, there was one crime scene. But how do you hide behind looking at every obvious extension of the crime scene, or what could be a second crime scene if we're talking about the Sallyport? It's just too convenient to say, there's only one crime scene. That was right there at 34 Fairview. Anything else, unless you specifically ask about it, sorry, not good enough. And then don't even get me started on how evidence, remember, they're talking about evidence, physical evidence. That's the request. That's the code.
Right.
She goes on to say, well, that doesn't include surveillance video.
I couldn't. This one, my note here is, what BS is this? Okay.
Yeah. I mean,
you all know what BS is. What BS is this? It says, exactly. And I don't know what number it is because I left my 39 pages right across.
Well, we're going to get to it. It's coming up.
Okay, it's coming up because I'm incensed about this part.
Okay, so this is another chunk about, this is the Brian Higgins phone video, 1:34 in the morning. He's crossing the parking lot at the ATF where everybody goes to, dump their cell phones or whatever. And so he's walking across the parking lot for just a few seconds, clearly holding a phone to his face. That's what we know, right?
Right.
So on October 10, he provides that rear lot. Brennan joins the prosecution team, and then he provides the rear lot cruiser footage along with surveillance videos, which include Mr. Higgins, right? Okay.
Right.
November 8th, this is a month and a half or so after Brennan joins the fray. The defense emails Brennan requesting all raw video footage from Canton PD, which shall include, but not limited to, all cameras capturing the interior of the CPD and or exterior of the CPD, including all parking areas, entrances, exits, garages, between a very tight time window here, midnight and noon, we'll call it, the next day, right?
Right.
Okay. Although I think they got that date a little bit wrong, to be honest with you. I think that's the wrong date. But Brennan responded he would request that the CPD collect and produce all of this information. So it's only during this process. Again, Brennan's new. He's new to the mix. I can't imagine what he's thinking when he goes through this case, which he's, agreed to take part in. During the process, Brennan came into possession of the main driveway side exterior Sallyport footage, originally obtained by Proctor in June 23 and not turned over to the defense. So Brennan decides probably should do that. Probably should turn that over, right?
Yeah.
But again, ultimately the court says just look the other way. And what the court says about that video with Higgins and the phone to his face, we don't hear any audio. We don't know what's happening. We don't even know if a call is underway, you know?
Right.
So what's the big deal? I mean, what are you missing? It's just too big a reach to suggest that was anything nefarious or somehow connected or exculpatory for Karen Reed.
By the way, Amelia Walsh, thank you for becoming a YouTube member. Shout out to you back. Okay. Now where do we go?
Okay, so now we're at the physical evidence distinction.
Now this
Contrary to the defendant's argument, there was no court order requiring the Commonwealth to preserve or produce the CPD surveillance video before the first trial. And then the order of February 2nd, we're all familiar with it. It was asked to have preservation of, quote, all physical evidence. Okay?
including
including anything present or near the decedent at the time of the body. And remember, anything found at the alleged crime scene. So you want to look at this as narrowly as you possibly can. Then you're not going to think anything outside of 34 Fairview is covered, period. No
right.
matter how the case evolves.
Right, but it's all that's qualified by all physical evidence. All
Evidence.
physical evidence.
Evidence. Well, funny thing about
that a camera with a tape in it is not
no, that's
physical
not.
that's video evidence.
I'm sorry, LKB, that is just wrong.
Oh my goodness
Massachusetts case law reflects a clear distinction between physical evidence and video surveillance footage. Aha!
So she
and so she goes on to cite the cases there that stand for that
but then with the cases she cites, some of them mention videos and photographs.
Yeah, in lump sum, like communication, surveillance, and physical evidence in one string.
In one string. So it mentions that in one string. So by Yannetti being inclusive, all everything, apparently that's not good enough because you had to be inclusive but specific.
Mm-hmm. Not specific enough.
Not specific enough. And I guess she figured she gave him a pass on the attorney-client privilege. So, okay.
So that's the way it works. It's like, we're going to give you this one. We're screwing you on this
point,
one.
I don't know. I mean, you know how many attorneys I know who don't make these orders to preserve, who don't do that? He did 2 of them. The second one was actually denied by the court that's sitting, right? And here he does a terrific job, and yet he says no, videos are different than photographs of the crime scene and anything else. Okay.
And so to further,
incense
shred
me?
This, to further shred the details of this, when go to October 5th, 2022, this order on the motion to compel discovery references all crime scene photographs and or videos taken in connection with this case, emphasis added, and the CPD was not part of the crime scene. So of course we don't have to give you that stuff. Never thought of it, never crossed our mind. This was October 5th. The car had long been collected, stored, looked at. See, look at you. Domino is outraged.
Domino's outraged. And it's unclear why Trooper Proctor requested footage at a certain time also, which was before that. Why would you do that unless you wanted people to think there was no video footage of the Sallyport or the driveway or anything?
Here's another one of your footnotes. Let me see if this one was worth. This is another Rule 14.
And this is important. It's actually pretty important. Footnote. It goes, and I have it here. I printed it out, right? By the way, you know what my note is on this one? Sure, blame the defense, for not saying, well, we want videos of the Sallyport, footage of the car specifically, instead of, hey, and this is where you get to the issue of whether it's exculpatory or not, and this footnote here that you're coming to.
Yeah, and again, she references back and forth between the proposed rule and the current rule, and just continually circles back to the fact that the defense was not specific enough to get what they're now complaining they got late.
There's also a redaction when we get to footnote.
Oh, goody, another
6.
redaction.
When we
We
get
get
to
to play
footnotes.
what?
This is footnote. Yeah, this is
Redaction.
footnote 5 in regard. She talks about the standing committee.
Yep.
Right, and then she gets to, and I think it really connects to footnote 6, although you have other stuff highlighted before that.
Yeah, this is just what I think is just a, one of those look the other way. It's not clear on the record how or when the Commonwealth should have known that the surveillance video was germane to the defense. Really? Wouldn't have been like after you took possession of the vehicle? Wouldn't that have made sense? At that point, you thought, this may, we're investigating, even if you assume they did nothing wrong when the SUV was in the carport. And I don't know, so I wasn't there, but sure is suspicious with what is and isn't available about what was going on with that right rear taillight. But at that point, you should be thinking, okay, this is going to be important. But you don't think that if you don't want somebody to know about it. Until the Commonwealth knew, for example, that the defense theory included the law enforcement tampering with the taillight while it was at the Sallyport, or that Higgins was a proposed third-party culprit, it had no reason to inquire as to whether any video footage existed. So,
yeah. By the way, Amelia,
is that unfriggin' believable? Was that what
yeah, whereas I always say when I always call it a UFB. It's a little bit more, when my trial teams know when I say it's a UFB, I'm cursing. I'm doing the cursings. Amelia, who just became a member, had as a question: weren't the CPT conflicted out? Why would you leave it to them to find anything?
As they used to say, you can't find their ass with two hands. But
I don't think I've ever heard that.
You never heard that one? The question is, was it just bad policing or was it intentional? And every time I see something, I think more intentional than not being able to find your rear end.
But let's go to this footnote.
Okay, let me see let me make sure we've got everything before we
Number
jump into your
6.
favorite footnote, number 6.
My favorite
because
footnote.
it comes at the end of this first paragraph here, and we just finished that production during trial down. Okay, so here's the core. The production during trial was undoubtedly late. But look the other way. The defendant received the video more than a month before it was submitted into evidence. And because she has advanced no argument as to what, if anything, her counsel would have done differently if the disclosure had come earlier, the defendant has not shown she was prejudiced. Just look the other way. Okay, let's go to your footnote.
So let's talk about the strategy we would have had, and we can't advance the argument at which you would have done differently if we had evidence that maybe we would have assessed differently.
If you can't figure out what your arguments are going to be, regardless of the evidence we do or don't give you, I'm sorry, you're just not doing your job, defense.
Yeah, you're not earning the money that you're getting paid. Okay. So here's the footnote. Defendant also argues that the rear lot cruiser side camera footage. You got that? The rear lot cruiser side camera footage should have been turned over because it was exculpatory impeachment evidence that the defense could have used to show Higgins, quote, perjured himself before a federal grand jury when he testified he did not call anyone that night in question. Okay, got that? Yep. Defendant's memorandum at 20, all right, and apparently she cites, that's where they cite it. That argument fails for several reasons, says Judge Canoni. First, it's not all clear how, within the bounds of admissible evidence, the defendant could introduce evidence of this alleged perjury at her criminal trial. Well, he testified.
Why not?
Evidence of perjury anywhere is admissible as impeachment. Okay, that was my note. Second, even if a cursory review of Higgins' grand jury testimony reveals that he said blank,
which would be something, I guess, disputing that he was calling anybody at 1:37 in the morning, or that he was on his phone to anybody on that piece of video that he was captured in. That's my guess, because that's very specific stuff. Yeah.
Third, the video issue of a 4-second silent clip showing Higgins walking across the parking lot holding a phone near his face does not, quote, clearly show, close quote, as defendant represents. The witness, quote, speaking to some unidentified individuals on the phone, which is what we just talked about. Now, the clip does not reveal how Higgins is utilizing the device and in no way establishes that he perjured himself before a federal grand jury. So we can't get the evidence because it's gone. And then we can't argue that he perjured himself because we can't use the federal grand jury testimony because you're saying it may not be relevant except for perjury, but you're not letting us argue that it's relevant for perjury. Okay. Finally, in its regard, the remedy for non-production of this video clip is not dismissal because defendant's rights were fully protected by her ability to use it for all it's worth at the retrial. What? Excuse me? I thought you said we couldn't use it's redacted. We're not allowed to get there. We're not allowed to do that. And then in the footnote again, and I put oi, okay, with respect to the main with respect to the main driveway side exterior Sallyport, even if Proctor should have turned it over. This is the one that gets me. I'm going to start this again. With respect to the main driveway side exterior Sallyport camera, even if Proctor should have turned it over to Lowley prior to trial, the quality of the footage is so poor that it is impossible to tell the condition of the taillight or how close anyone was to the right taillight. To the extent the defendant contends that the footage could have been used to impeach Buchanan's testimony, she will have that opportunity at retrial.
Yep. Just look the other way.
Just look the other way. And she says, she gets into a discussion of exculpatory, okay? You don't even need to go to that. She says, it also is under the old rule, everything has to be exculpatory. And it's not clear this is exculpatory, right? It could be impeachment, but it may not be exculpatory. Under the new Rule 14, it just has to meet some type of relevancy standard for the defense to be able to use it. And I forget the exact word the new Rule 14 has. It's in it's in a footnote, okay? And so therefore, and actually, here it is. In the regard to the revised rule, the prosecutor's duty to inform and inquire, collect, disclose, preserve, and notify and record are subject to that rule, which means, if it could be relevant, they have a duty. Yeah, they have a duty. But the defense can't show exculpatory under the old rules, and therefore there's nothing I'm going to do about it because now we have the new rules, and under the new rules, you have the right to cross-examine. But I'm sorry, you don't have the evidence.
The new rules aren't in place for you, so.
Yeah, the new rules weren't in place for you during the first trial, and all. Okay, it's like a Sophie's choice, right? You're damned if you do, damned if you don't. One way, it's protected this way, it's protected that way.
Yep. I know this is one of your favorites, the metadata.
Oh my gosh, I did write a footnote. Yeah.
So again, now we're page 13 here. This is about a third of the way through, but it flattens out a little bit after the next few pages. The defendant did not make any specific request for the original footage with metadata before the first trial or before it was overwritten. There is nothing in the version of Rule 14 then in effect, or the current version, that entitles the defendant to the metadata or log files underpinning surveillance footage in the possession of the Commonwealth, and the defendant has not directed this court to any authority suggesting preservation of such evidence is required. I mean, the way you're pairing this out, if you want to read between the lines, if you see a case going forward, you're looking at this and saying, okay, here's what I can mess with. Here's what I can delete. Here's what I can ignore. Here's what I don't have to cough up, even if it's exculpatory, because we're drawing a distinction between the metadata and the actual surveillance footage.
Right. So, and my note to myself as I read this quickly, because this came on just before we were getting ready to do the show. Okay. Are we in the 17th century or even the 20th century? Now everyone knows what metadata is. It's just like back in the 90s when you asked for what we call bench notes or laboratory notes, because that's where your forensic evidence was that showed that things were exculpatory. It was not in the actual scientific report. Now everyone knows that. But in the metadata, what are we talking about? If you're preserving the video, the interpretation of preserving any video is to preserve the metadata. That's what the police are looking for, right? They're looking for when something was sent or when something was changed. They download the metadata. Hello?
Yep, but by drawing that distinction, I think it's going to be abused in the future. That's my guess.
Yeah. And so, so the metadata, apparently you have to specifically ask for metadata. Now, so they get around this whole idea that the video was, remember the whole idea of the defense wasn't told that first they were told the video was overwritten. Then it turns out there was a copy of all these videos that weren't deleted on another drive. And then it turns out that that drive was put on a jump drive by somebody else 2 days before he retired. And then it turns out that that jump stick, without the metadata, because it was
Cut and pasted, I guess.
captured by drag and drop, which deletes the metadata, changes the metadata, was in Trooper Proctor's file. So if you're not screwed, defense, on one aspect, you're screwed on another aspect here. That's what this opinion is basically saying.
I didn't see that. I didn't see that in the decision. But
you didn't see that? Well, that's my interpretation.
If you're not screwed on one, you're screwed on the other.
Well, that's my interpretation, because if you argue this, well, then there's this. If you argue that, then there's this. So if you argue that you even if the defense had asked for the video, the answer would be, well, you didn't ask for the metadata, and therefore that's so what?
Okay, so here comes another footnote with another cover for the prosecution. Moreover, during cross-examination, Jackson questioned Buchanan extensively about the video being inverted, and even played a corrected version of the video that was not inverted, leaving no doubt in the minds of the jurors that the video played by the Commonwealth was not a fair and accurate depiction of what occurred inside the Sallyport. Thus, the disclosure was sufficiently timely to allow the defendant to make effective use of the evidence in preparing and presenting her case. So again, because you're so good at your job, defense counsel, you were not prejudiced, therefore we're not going to help you, and we're just moving on.
Yeah, our friend Neil
it's outrageous.
That, right? It's outrageous. And by the way,
be penalized for being good.
After it says, and I think I just saw a note up there that answered, don't you need the metadata for identification? Yeah, that's usually how you identify properly, is for the metadata, and also to know if things have been changed or not.
Yeah, otherwise, especially these days, to find out, deep fakes and whatever other altered video you can create, without it, who knows what you're really seeing.
Yeah, and then we also have a question from Jason Hodges. Can they appeal this ruling? Good luck on that.
Yeah, obviously, this is if there's a conviction, this is kind of the outline for the first appeal. All of these issues will be thrown back in the form of an appeal if there's a conviction.
If there's a correct, all these issues will come, and then there'll be some other stuff. I mean, well, during the course of trial, there will be more, right? Things that involve objections, which of course won't have the ground, so we won't know what they are. That'll be those issues. What evidence is allowed in, what evidence is not, what motions in limine are granted versus adjusted during the course of trial. All that stuff is going to go into the appeal tank if there needs to be one. Remember, we talked about the Jennifer McCabe statement. The whole to me, this was something. I wasn't really that connected to it. I didn't see it as a big thing, but she went and saw. Is it Officer Lank? I want to make sure I give him his right. Yes, it was Lank.
Sergeant Lank.
It was Lank.
She was going there with a friend who had to pick up kids, and there was or wasn't a conversation. She had said early on that she never went there. It was later determined that she did, and she said, "Oh, I forgot," but then continued to say nothing ever happened. There was no real conversation between Sergeant Lank and herself regarding this case, and so that was an issue that the defense thought was worthy of bringing up in this motion, and they did. I didn't think it was a biggie, and we talked about this too, and I sided with the court actually, because the defense learned about this visit during trial and during cross-examination. He touched on it, but learned more after the fact, remember? And then the judge said, hey, you want to bring her back? We'll bring her back. During cross-examination, Jackson questioned McCabe about the details of her discussions with Lowley, McLaughlin, and Tully about that trip to Lank's house. She testified when Tully asked if she went to Lank's house on January 30th, 2022. Remember, this would be the full day after the overnight event. At first, I said, no, I've never been to his house. Then I thought about it, and I said, oh my gosh, yes, I did go there, and that was the extent of the conversation. So then she's excused at trial, and it's only then that Alan Jackson is thinking, well, I never got into that because it wasn't revealed till she was excused. He was given the opportunity to bring her back. The court offered to allow Jackson to call McCabe back to the witness stand. Jackson declined, stating, no, Your Honor, I'm not. That's not I think the court understands. That's not my point. My point is not that I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe. When the court asked, you've what? Jackson repeated, I've done the damage that needs to be done on Jennifer McCabe, and stated, I don't need to call her back. So I do agree with the court on that one very specific issue. He had a chance to call her back. He did trash her. I'm not sure it would have been even more helpful to say, here's one more incident in which you have misled or lied about your involvement. But he had a chance. He didn't do it. Too bad.
Yeah, and it's always a problem when courts offer the opportunity to do something again. I remember, Inspector, we had a pretty severe hung, and the court offered us opportunity because the court wanted to recharge on a theory of the case that Alan Jackson had never put forward, and we said, no, Your Honor, we don't want to have any other. We're not closing on that. Sorry, when courts offer you the opportunity to do something, usually not a good thing. They're not trying to help you generally. They're trying to cover the record. Yeah,
exactly. And it would have been glaring had he not made if he had just said, well, Your Honor, we're not going to do that, and not explained why he wasn't doing it.
But I understand why he did, because remember, the courtrooms this is a media event, right? And so he's saying, I trashed her, and people were feeling like she's trash, and those.
Oh my gosh! It was brutal.
Oh yeah, and then it was brutal, and then others were people. Why are you trashing this woman? Is just trying to tell the truth. Yeah. Micah has a question, by the way. This decision is like filing a claim with your insurance company. Denied for all the reasons. Your surgeon will have to call the day before you're about to die before we approve. And usually, then they may deny too.
Yeah, that's true. Yeah. Or your deductible is so big, it doesn't matter if you got insurance or not. That's a whole different analysis. But I understand the comparison. So let's see if there's anything else I noted on here. I think some of these conclusory statements, by the judge, just the defendant has not demonstrated that she suffered any actual prejudice based on the Commonwealth's late disclosure or failure to disclose evidence before the first trial. Just, okay, so look the other way. Don't worry about it. Let's see. Oh, and this is interesting too. She's basically letting the prosecution and law enforcement off the hook, suggesting none of this stuff, if it happened, even as you say, it was not intentional. Nor has the defendant shown that the Commonwealth's conduct was so egregious, deliberate, and intentional that prejudice should be presumed. So all of these things, Linda, happened by accident. All of them.
Every single last one of them.
You realize that it was all accidental.
I mean, there should be like the defense obviously argued it, but as I say to people all the time, and I explain to everyone watching that, when the jury's in there discussing things, sometimes it helps to have a checklist, right? And by the way, speaking of checklists, Judge Canton said it was suggested that under the new Rule 14 there'd be a checklist for people to check off. Did you notice that as to what they're asking for? How about you just save everything and turn over your whole file? How about that? Okay.
Yep.
Wouldn't that be novel for justice?
Well, this is where I kind of ran out of gas.
Okay. Why don't we
This is the jury misconduct.
Yeah. Why don't we mention that? Because I think our plan is on Thursday to go through that in great detail, and maybe tonight still touch upon there's another defendant's memorandum in opposition of Commonwealth's motion in limine to exclude Michael Eastwood's testimony. So why don't we just mention the juror misconduct briefly, which is this. Go ahead,
lay it out for us.
Yeah, and I don't know the history, because this is one of the juror that was called to the bench. Apparently, I don't know who she was dimed out by. I don't know if that's in that opinion. Okay. And they said that it's been reported to her, and maybe this was where the whole Lieutenant Fanning thing came in, if I read that opinion right. All right, that this juror was at the American Legion. There you have the transcript.
Right here is the
it's been brought to my attention that you have been recently at an American Legion or Knights of Columbus, someplace like that. Someplace like that. The two are so easily confused. And then someone reported, I wonder if that could be, that you have been talking about the case. What can you tell me about that? And the juror says, I don't know. The court, have you been to an American Legion Hall? Juror, like a month ago. Okay, at that time, what were you talking about? The juror, we talk about what were we talking about? I assume about the case, and the juror interrupts and says, no, not that I remember. Do you remember if people there mentioned to you anything about this case? The juror, I was drinking. I don't remember. And remember, that's people mentioning to her about the case, not whether she's talking about it. Okay. The court. Okay. The further information I have this morning, several Dedham police officers said they heard the same thing. Huh.
Several.
Several. The juror, okay, all right. Could it have happened? The juror, I don't know. Okay. The juror, I really don't know. Could somebody have mentioned about the case? But when you're on that, you're supposed to ignore that. Hey, somebody mentioned about the case, so you're drinking, you just ignore it, right? Month goes by, you're not paying any attention because you don't disclose anything about the case.
Yeah, if you're just sitting there, crying in your beer or whatever you're doing, and there's conversation going on all around you, and you're not participating, how is that a problem?
Right. That's the issue. I mean, and that's where this doesn't go. And then she said, this is the second incident that's been reported. We don't know what the first incident is. And we know the defense has taken, we heard from Scott McGinnis the other night that the defense felt that she was specifically targeted because they felt that she was a juror that was likely to go in their favor. And it's not because you know that. Okay. If you try enough cases, you know which jurors, because you've picked them, fit all the targeted criteria for what you're looking for. Maybe you saw her kind of like making faces. Some of the jurors will make faces during testimony, or like, what you say, and you see that, and everybody sees that. It's not unusual. And so they would have put her in their category as somebody who wasn't going to vote for guilty, a verdict, right? So, but this to me doesn't say that she participated in this conversation. And the fact that 3 Dedham police officers, were they following the jurors?
Yeah, what were they doing there? Were they just hanging and just happened to be there? I mean, if it was at the what is it, Knights of Columbus or whatever?
American Legion, I think.
American Legion.
Yeah.
Yeah. I mean, that wouldn't surprise me to see officers there, just because of the background and the type of organization it is. I don't know. I don't know what the jurors' connection might be to that either. So it is weird that several officers heard it. That's weird.
That's weird, or reported to her. Reported. So Micah says, "What? No more negligence charges in Massachusetts." That cracked me up. But so they reported. So where did they hear it from? We don't know. And we don't know whether there was never a further inquiry, because this is what's being released, right? We don't know whether that whole transcript's under seal. All we know is the defense did ask for didn't they ask for at sidebar more of an investigation into Lieutenant Fanning, and maybe that's who it all came through. Maybe it came, we don't know. We don't know.
They just say a discussion about Lieutenant Fanning ensued with defense counsel, suggesting Fanning and the Massachusetts State Police might be targeting potential jurors for the purpose of trying to get them excluded from the jury. So then you have the court making a decision, right? Talking about Fanning's role. And there was this big controversy. Is he in charge of the jury? Is he a supervisor for security purposes? What exactly is it? Because the thrust of the defense argument here is that Fanning was in charge of the jury and was acting inappropriately in things that were said and done while in charge of the jury. Thanks, Shy Gal 8, for the Justice Serve TV membership.
Right, and it wasn't so much that he interacted with the jury. It's just that he interacted with the court that brought things to the court that may have been, I think the defense was saying, some type of jury tampering from outside, whether or not he did it knowingly or not. We would point out that then Hank Brennan came to his defense. He's the greatest trooper, or the greatest officer there is. And then it turns out that he was also the one in the Sandra Birchmore case who said that it was a suicide, as opposed to a homicide or a charge of murder, right? Sunshine says because of Sandra Birchmore. So I think you and I think this is a significant enough issue that we want to do some more investigation and talk about it in more detail on Thursday night. If that's okay with everybody here, unless you have a specific question about this, because we think this is really something that if indeed there was some type of interruption of the jury process by getting somebody who's good for the defense or interrupting jury deliberation, could, if there was ever a conviction and a mistrial, come back, even though you have the interim charge of interim decision of a second jury. This could come back. This is a serious
So obviously, here's the upshot. Here's the end result. The court conveying the decision. This is the court, believe there is credible evidence that this juror has had conversation about this case. I don't know where that comes from, because all we know is that there were people talking about it, not necessarily this juror, but nonetheless, she did not deny it. I find that there has been violation of the court order for failure to report it on a repeated basis. Juror A, of course, that's the woman in question, had no problem reporting the other juror, but then at this time did not tell us that she spoke to 2 other jurors I inquired of. Now, there were 3 ultimately, right? So I'm not sure where how this evolved, but this was how the judge ruled on this one particular case. She told us it may have been overheard, and then it was another juror identified by seat number who ultimately told us that this juror had reported to her what the other juror had said. That was juror number A. Juror A, letter A, may not remember whether she spoke about this case, but I wouldn't be surprised if she remained as a juror if we did hear from somebody who was at the VFW that night after all of this. What a weird thing to put in the decision.
It's really weird, and that's why
I wouldn't be surprised. Is that the level now of proof? I wouldn't be surprised if we heard from somebody else that was there that night that heard about this. So for all of those reasons, I'm going to excuse her from sitting on this jury.
Yeah, and this is why we would say, so all of you who are following this case, put your tentacles out there. See if you've learned more, heard more that you could get to us before like tomorrow, so that Thursday night when we discuss this, because we are going to discuss this in greater detail on Thursday night. So 2 major things today. Again, the issue of the breach of privilege not granted. Granted, the defense benefited on that, but the motion to dismiss, the defense clearly did not benefit. And by the way, there was other things we talked about earlier today about there's the unsolved productions footage that they're going to have to deal with. But what the defense did file tonight is a defendant's memorandum in opposition of Commonwealth's motion in limine to exclude Michael Easter's testimony. Whew, that was a mouthful.
Okay, let me pull that up here.
Okay,
we'll park this one here for now. Okay, and then we will get this one. Stand by.
Okay.
This one also was filed not all that long ago.
Right. This actually has a filed stamp on it, March 25th.
Okay, that would be today.
2:49 p.m. Okay, I'll let you know. You've been asking for a filed stamp. Here you go.
Yeah, I do like that. I do like the file stamp.
And they
and you can actually read it. Sometimes you can't even read them, but yep, that's pretty clear.
Yeah. They finally heard you. And this is the defense's motion. Remember Hank Brennan. So the defense has a report from somebody who has testified apparently a gazillion times. I mean, I'm exaggerating, but a lot of times as a police procedural expert as to what are the proper procedures you take to preserve a crime scene, right? Yeah. Seen in a lot of cases, not a big deal, right? Usually that happens. The prosecution objected in their in limine motions. They want him not to testify. His name is Michael Easter, on the basis of this ain't done in Massachusetts. I think is the basis, right?
This is not the way.
This was yeah. Let me show you the way, or this is not the way, right? And so again, the prosecution wants to cut the defense off at the knees from having an expert to testify about what the proper procedure is. I guess the prosecution's theory would be, red Solo cups, any juror can figure out for themselves that's not a proper procedure. I don't know. I'm just making that up. I mean, so that was a little bit of a dig there, right? And so if it can help a jury and it's experience-based and he has the qualifications, a defense expert usually is allowed to testify. And they want to bring in somebody to say this scene is not preserved well, right? It's as simple as that. And it's not preserved well, wasn't handled well, and all. Apparently, unless there is case law in Massachusetts, and I'm trying to look for it. In Commonwealth versus Dyer, 460 Massachusetts, 728, 2011, a defendant claimed ineffective assistance of counsel. And the reason why I mention that is because you recall Judge Canoni said to Alessi, do you have any Massachusetts case law? He said, well, I have case law from all over the country. It's allowed everywhere. He said, I want Massachusetts case law. Defense counsel's failure to hire a forensic expert to testify regarding crime scene investigators' failure to investigate certain gunpowder residues and conduct of additional testimony was a violation of the effective assistance of counsel, a Sixth Amendment right. In that case, the Supreme Judicial Court, that's the Supreme Court of Massachusetts, held the trial counsel's failure to present an expert to testify about these investigative failures was not manifestly unreasonable because the proposed expert's affidavit failed to address the fact that the testing was reasonably necessary in order to have a proper police investigation. And what the defense is saying, well, here's one that says you can't do it, but only because you didn't satisfy the requirements of Rule 702. And here we have satisfied the requirements of 702 regarding our Bowdoin defense. So that's what the defense is saying. So they're saying,
and it seems pretty straightforward. And I know that Judge Bev was pressing Alessi to come up with something more than the way authority works. Just to open up the justice served classroom here, you've got persuasive authority, you have controlling authority. Controlling authority would be the Supreme Court of your state or the Supreme Court of the United States. But if you're going outside of Massachusetts, you have a tremendous California case that's right on point, you can use that, but it's persuasive. It's not controlling, and a court can just dismiss that as however they want. It's not controlling and binding on the court. So the judge was asking for something. Give me some good stuff. Give me something strong enough.
So, but it's such horrible case law that you have.
I know.
If it satisfies 702. By the way, this is an interesting question. I don't think that's the case here because it was apparently somebody at either the VFW or the American Legion. I'm not sure which anymore. Just wondering if that dismissed juror was overheard by Chris Halbert's D&E pizza camera surveillance. Wouldn't that be interesting?
That would be ironic.
That would be really ironic and all. Yeah. The jurors are going to lunch. The jurors go to lunch at D&E Pizza, right? They get overheard walking over talking about the case. That would be ironic. So anyhow, so the defense did file this, and it's a huge memorandum of law because remember Hank said that you can't second guess what police officers do in their investigation. Well, you're not second guessing. You're saying, well, something is done wrong based on even the protocols that Massachusetts sets forward in their, in how they teach crime scene preservation, right? So that's where we are. They did file that, and now this
is what I call the do it opposite.
Do it, right? This is the
do it.
Right?
Because it was in response to this argument that, hey, we can come in and say the investigation was flawed, and if there's some slop over that supports our third party culprit position, too bad for you. The jury is allowed to make that connection. Hey, the police investigation was crap, therefore we don't know who could or couldn't have been involved as a third party culprit.
Yeah, and that's what Hank,
Brennan.
Yeah.
Well, what do you want us to do? You want me to call some Massachusetts State Police to say that the investigation was the best it's ever been?
What do you do? Do it.
Do it.
Yes.
You do it. And that's what he said. It's called rebuttal.
Yeah. Even Judge Bev was like, Mr. Jackson, wouldn't you object if the prosecution offered to bring in someone from the Canton Police Department to say that the investigation was perfect? No, of course. Bring it on. Oh man,
I would say just do it, but that may be a copyright infringement on Nike. Do it.
That's one of those moments where I think, is the judge that tainted that she doesn't see that? Because it's such, that's a first year law school response to that kind of back and forth, that kind of potential. But it sounded to me like she really believed that the defense would object to that.
Right, because he's not
weird.
It's weird. Maybe if he was a former Canton police trainer, of some sort, I'm not sure how good that would be.
Or
if she'd allow it. What are you going to
I'd say, well, Mr. Trainer, then what day do you have class about collecting evidence in red Solo cups? When do you have the instruction on leaf blowers to remove snow? from a crime scene. I mean, when does all that happen?
As a matter of fact, I'm going to be at the cabin, as you know, this weekend. I'm going to take out my leaf blower. Now, it's the first leaf blower I have owned. It's an electric leaf blower. You could imagine me with a leaf blower. That's going to be that'll be a picture in of itself. But I mean, come on. I mean, I didn't buy a leaf blower to get evidence away.
When I saw the video of it, I wasn't as outraged as I was just at hearing about it and thinking about it, because there was very light snow that they were blowing away. But it's destroying the crime scene. It just wasn't as violent as I expected.
Yeah, but you don't destroy things that may have been on there or on the
really?
top. You take it away. You have to take the whole thing. You're gonna maybe put a plastic covering underneath, let the snow melt into it, and then turn it over, right? I mean. Oh my goodness gracious. I can't even. So anyhow, it was a big day in court. And as I said, we do this motion to dismiss is so huge. And apparently, I think we don't have there's a couple other minor things like whether it's 500 feet or not. We're
the buffer zone. Yeah.
Buffer zone. We're putting it in and all. We can get to that a little bit on Thursday, or we can tweet about it or tweet about it, about that. That's just
updated
and talk to Aiden about it on tomorrow night. Aiden Carney about it tomorrow night, and about what the buffer zone means for any Karen Reed supporters. But you could also have supporters of
last time
Constitution.
There was blue and pink. Remember, they were kind of separated. The blue for the O'Keefe, I'll call them the O'Keefe supporters, although that's not really appropriate. It's not like the Karen Reed people are anti-O'Keefe, but you know what I mean. They had those color lines drawn, and I'll be up there, so we'll see how well the buffer.
And we're in blue. We try to be fair. We wear blue and we wear pink.
Blue's my color. Pink, not so much. So, okay, so I think that's about it, right?
You sexist.
I am. I admit it. It happens.
We need you to all hit that like button before we go, because we are, just so you know what our schedule again is, I'm going to talk while you hit the like button. Hit that like button. Please hit that like button. It gets us into the algorithm.
The world is on fire. I want you to take a picture of you using your leaf blower. I just want to make sure you don't break a nail.
Well, me too. I'll bring it. I'll try to bring it on the set. And then, of course, hit the like button. But we do have tomorrow night, 8 o'clock. 8 o'clock at night, we will have Dr. Turtleboy on. Aiden Carney's going to come on. That'll lead to me getting trolled again. No problem. I can handle it. That's man, great. It's so ridiculous that we can't discuss legal issues like grown-ups, right?
Yep.
Then Thursday, we're going to go more into this juror issue, and we may have a guest on to help us. We're trying to sort that out right now. And then Friday, we have two things going on. We have Doug Weinstein coming on our show at 5 p.m. because he has some really interesting takes on this, and not some that either side's going to like. Neither side's going to like his takes. Doug.
His is a much more neutral observer kind of take, because he's been busy, doing other stuff.
Right. He's big picture take. And then right after that, at 6 o'clock, we're going to go on Will DeGlara's show as guests on his show. And then some people who are free Karen Reed people may not like some of the things we have to say. I mean, because we call it as we see it. That's why we hope that you come here, because we call it as
more than anything. We would like to see a little justice served for Officer John O'Keefe, and everything we've seen unfold up to this point tells us it ain't happening, unfortunately.
That's right.
All right, then. Until then, I'm Michael Bryant. Hey, try to do the right thing.
And I'm Linda Kenny Bodden. Hit that like button, the subscribe, the share, and the notify, and we'll see you tomorrow night at 8 p.m. Eastern.